ladies and lords. I propose now to turn to ground 2 and then to respond to Mr. Brown's points on prejudice. So, as regards ground 2, the first point is that before even looking at the issue as to whether there was an inference here, objectively, a period of 5 months and 2 weeks is not submitted unreasonable delay in the context of this claim and defamation claims generally, and that even without looking at the detail of the evidence that was before the judge, it was perfectly possible for him to conclude that the claimant had acted reasonably promptly as an objective assessment. 5.5 months, where 2 of them include the long vacation, is not objectively a long period of time. And that is all the more so when the context of this litigation is considered. And it isn't a simple case of just looking at a defamatory letter and assessing whether or not proceedings should be issued because of the existing litigation. The essence of the defamation claim here is the key aspect of it is an allegation of VAT fraud. And that's not something that anybody could look at and make a determination about quickly, particularly not in the context of this case where there was other litigation to take into account. So turning to the ground of appeal, I'd ask the committee to turn to the authority of Stun, which is in volume 7, page 1506 is the reference. It's page 1285 of the authority at D. Lord Justice Peter Gibson. And I'd ask the board to read that the final part there, beginning after the quotes, "When did you first forget?" beginning every court in the land to the end of the paragraph.
Well, can I just make sure I'm on the right page? This is page 1285 of the authority.
Yeah. Yes, the authority. It's page 1506 of the bundle, and the second paragraph of the page begins, "I reject the submission of Mr. Chapman."
Oh,
when did you first forget? I love it.
Yeah.
So that section, "When did you first forget?"
That was about drawing an inference of prejudice.
Yes,
apparently.
This was a want of pure prosecution case where there was 4 years delay. And the point I would make here is that that's exactly right. Every court in the land is accustomed to drawing inferences from private ground. And if there is anything in the appellant's second ground, it's submitted that the business of the entire court service will grind to a halt. If they're right and those kind of inferences are impermissible, there will be plenty of judges who would be unable to do anything in the court service. Stop. Then I'd also ask the committee to look at Manzi against King's College Hospital, which begins in the same bundle, 7, at 1386. This puts a decision of the Court of Appeal, and this puts a gloss on the case that the appellants rely on, Wisniewski against Central Manchester Health Authority. This is, again, both of these cases are medical negligence cases, and it is accepted that this is a slightly different issue because this is drawing inferences from oral evidence following trial. But what happened in this case concerned an issue as to whether the claimant who'd given birth had retained a part of her placenta, and whether it was a small piece, in which case there wasn't any negligence, or if it was a big piece that was likely to result in hemorrhaging, which should have been identified. And the at page 1390, at Roman numeral 7, is the assessment of what the judge did below, and the doctor there referred to was someone who didn't give evidence. And the previous paragraph, Roman numeral 6, is the evidence that there was about in relation to her. She'd completed a note. And the part that I rely on as regards inferences is at paragraph 28.
I noticed the word entitlement is used.
Well, I would submit the focus of the appellant's case on entitlement is again, another example of semantic clutching at straws, I submit. Paragraph 28 sets out there the principles derived from Wisniewski, and the part the respondent relies on in paragraph 30. And if I could ask the court to read that first section up to where it begins second. So the first point.
It's using discretion in the sense of choice, not discretion in the strong sense of you've got a variety of considerations that operate upon whether and how you exercise a power.
It is still an exercise. In this case, it is an exercise of discretion because it feeds into the question of whether it's reasonable and prompt. So the point there are two points that I take from this. One is the discretion point, and the second point is that, which you could see at 28.4, is that if there's some credible explanation, even if not wholly satisfactory, the potential detriment of silence may be reduced or nullified. And it's submitted on the facts of this case that the presentation of the respondent's evidence as being silence is simply not right, and that there was evidence about this, and even to the extent that it was considered to be unsatisfactory, or that it could have been better, that it was more than enough for the Deemster to form the view he did. If I could ask the committee to look at the case for the respondent at page 1253 of bundle 6. That lists there the facts, the primary facts that were an issue and were known to the court below. And the committee's already looked at the evidence of Mr. Willers on this. And the key points are that the claimant acted promptly as soon as he knew about the letter. That's in his own witness evidence, where he instructed his advocate on the Isle of Man. And on the 29th of June, he sent it to his English solicitor. And then on the 7th of November 2013, a letter before action was sent to the second appellant, which included draft particulars, and this is in bundle 5 at page 1076. 1089. So, yes, but volume 5, 1089. And this is the letter before action. And if the committee turns forward to 1094, it can be seen there that the draft particulars of claim were sent with that letter. And then what happens then is the response comes back on the 15th of November 2013, which is at 1098. And it's denied at paragraph 2 that the words are defamatory of the respondent or that they would have caused any damage. And the proceedings were issued on the 5th of December. And there are two further points that I would add to this. As I've already said, the period between June and November does include the months of July and August, and that's something which is entitled to be taken into account. And there was other related litigation in train.
When is the long vacation in the Isle of Man? Long vacation in England and Wales is August and September.
I think it's July and August. In fact, their procedural rules do specifically refer to the long vacation. But anyway, the point is it includes a period of time when many people are typically away. But the other point is that there was this other related litigation, quite a lot of it. And Mr. Brown mentioned 60-odd lever arch files. I'm told that the trial before Lady Justice Rose had 72 lever arch files. And it can be seen in this case that there's...
Sorry, I misled the committee.
It can be seen in this case that there's an email from the Isle of Man advocate. I won't ask the court to turn it up, but the reference, if you need it, is volume 6 at 1215, where it refers to 9 lever arch files of 1,990 documents. And it is the case, obviously, that the Deemster Cornet had knowledge of the other proceedings, and taking all of this into account, it's perfectly that there's enough there by way of primary facts for a court to conclude that 5 months, 2 weeks was acting reasonably promptly, particularly because particulars of claim had been drafted. And beyond that, I think that there is the court should also have in mind the principle, a public policy principle, that acting reasonably promptly doesn't mean acting with undue haste. And a line of authority that requires a claimant to jump immediately into issuing litigation without taking time to reflect, to take advice, it is not the way the law should develop, and would not be in the interests of the overriding objective of justice. And that the Deemster was perfectly entitled to conclude that this was acting reasonably promptly, and that the staff of government had it exactly right when they say in their judgment at paragraph 54, which is in volume 1, page 84, the final sentence there, that the Deemster could have expressed himself in more uncontroversial language such as reasonably infer. and that's right, and when it's analysed, that's really what was going on here. It was a reasonable inference, and one that the Deemster was perfectly within his discretion to draw. And it is again an example, as I said, of this being a linguistic quibble about the way a judge has expressed his findings rather than a substantive decision and the process that backed that up. I would also just, my learned friend referred to Steedman and the BBC on this ground, in particular paragraph 45. And I would this is to turn that up again. That's volume 7 at 1528. Which is the point that was made here, that if little information is placed before the court when inviting a Section 32A discretion. I would draw the attention of the committee to the facts of that case, which are entirely different from the facts of this case. That case concerned a television broadcast on the 16th of April 1999, where solicitors were instructed within a week, but the claim wasn't issued until 1 year, 3 months later, in circumstances where there was a complete unexplained delay of 1 year and 3 months since the instruction of solicitors. That's not this case at all. There is evidence that the claimant acted promptly, and my Lady Hale's point just before lunch, that it could be said that actually when looking at this exercise of discretion, the key issue is the delay to be laid at the door of the claimant. And what is known is that the claimant acted promptly in instructing solicitors. And so that passage in Steedman, I submit, isn't something that is applicable in this case. And so, taken as a whole, really, again, this is just about the language of expression of the judge, and that he was perfectly entitled to draw the inference he did. So, turning now to the response to the points made about prejudice, if it's to be said that the discretion should be exercised again. Obviously, my submission is that that's not something that this court should interfere with. The starting point here is Brady, the authority of Brady. I won't ask the court to turn it up, but the reference is volume 6, 1276. But the refusing to disapply the limitation period will always prejudice the claimant, and disapplying it always prejudices the defendant. And balancing those factors is going to be the same. It will depend on the particular case and issue. But in any case, there's going to be those two prejudices operating against each other. So to turn firstly to the prejudice to Mr. Willers, there's three key aspects of the prejudice to Mr. Willers. One is firstly the total loss of the claim in the abstract. The second is the loss of his right to compensation. And the third is the loss of his opportunity for vindication. As to the points made that there's no damage, I have 7 points in response to that. The first is that it's an oversimplification to say that vindication is the only legitimate aim of a libel action. And there is a danger, I think, in some of the authorities that aspect, the vindication aspect, is being overemphasised and that the law may be about to take a wrong turn. Any libel claim has three main purposes. One is to compensate the claimant for distress and hurt feelings as a result of publication. 2 is to compensate for the injury to reputation. And 3 is to serve as an outward and visible sign of vindication, so that any interested bystander can see from the sum awarded that there was no truth in the allegations. And there's a reason why damages are awarded in defamation cases, because it includes that compensation for distress and hurt feelings. And if vindication was all that was required, the law would only provide for declaratory relief, but it does not. At one level of abstraction, it can be said that a purpose of the libel action is vindication, but it's incorrect to elevate that to the sole purpose. And it's easy to think of cases where there would be no need for vindication at all. An example would be, say a sportsman was about to enter into or entered into an endorsement deal worth millions with a leading sportswear company. A woman emails the decision maker and alleges he sexually harassed her. The decision maker doesn't believe it, but decides that they will terminate that contract as a result of that statement. So the sportsman hasn't got any need for vindication because it's the statement's not believed, but that's not really what the damage there is. There's significant financial damage without any need for vindication. So there are plenty of situations where there isn't a need for vindication and that libel compensates for distress and hurt feelings. So it can't be said in this case there's no damage in that regard. The second point is that damage from defamation includes hidden damage because of its insidious nature. The well-known phrase, which I'm sure the court is familiar with, the propensity for, this is from Lord Justice Bingham in Slipper and the BBC, a feature of harm to reputation is the propensity for defamatory statements to percolate through underground channels and contaminate hidden springs. And as a result of this, a claimant may encounter a defamatory allegation being raised with him many years later, and where libel proceedings have been pursued, the person is equipped by a means of a judgment to refute that defamatory statement wherever and whenever in future they may run up against it. And in this regard, I think it should be taken into account that this is the Isle of Man. The population of the Isle of Man is in 2017 was approximately 84,000 people, 84,000 individuals, and it is a smaller community, and it isn't. There's a real risk that there would be hidden damage in this case. As regards this point, also it may be worthwhile looking at the transcript of the hearing before the staff of government, which volume 4, page 762. This goes to the point about hidden damage and when it may occur. So page 762, at line 18, the Deemster makes the point that if this kind of letter is on file within government records that are retained and open to inspection by other third parties, that may be something to concern a claimant. And then over the page at 764, line 3, His Honour Judge of Appeal, Tattersall QC, makes the point about government records being computerised and being accessible. And at 18, there's a request that VAT authorities try and justify their existence whether they're investigated fully and whether or not these kind of documents could be produced in freedom of information requests. The point I want to make there is that this is a document that is, as it stands on file, with a public authority, and it's perfectly possible that it may be something that resurfaces in future as against the claimant, who, absent his libel action, has no means of addressing that. The third point in response to damage is that the argument that there's no damage here is bad for circularity because it puts the cart before the horse. We don't know what the damages are because there hasn't been a trial. And the appellants can make any point that they wish to make in that regard in reduction of damages. And this point was addressed specifically by both the staff of government and the Deemster Call It. The staff of government references paragraph 70, page 89, where they said it will be a matter for a court or jury to determine the seriousness of the allegations in the matter. And Deemster Call It at paragraph 70, where he said it's not possible to say at this stage what view a Deemster or a jury would take of quantum.
Both paragraph 70.
Paragraph 70, yes, it's page...
Both instances.
Oh, I'm sorry. It's page... Let me just double check that then. It's page 89, I think, in the...
Yes, coincidentally it is.
It is. Yeah, yeah.
But no, that's 89 is staff of government.
Yeah,
isn't it?
89, and then 68.
I think we were asking you whether it was also 70 of the Deemster's judgment.
Surely right to say at this stage that it is not possible to say what view a Deemster or a jury properly directed might take of quantum. That's paragraph 70.
First rate. Nice coincidence.
Yes.
Doubt my references there. The fourth point is that compensation also includes compensation for how the case is run. And here it bears repeating that the defendants are pleading justification. And this also is a point in favour of Mr. Willis being able to maintain his action. The fifth point is that there's a claim for aggravated damages and allegations of malice. The sixth point is that the law presumes damage and defamation. There is some discussion of this by Deemster Call It at paragraphs 56 and 58 of his judgment. And the seventh point where my learned friend alludes to the point, the game being not worth a candle, that's not a point that's open to the appellants to run in this court, I submit, because a Jamil application was made to Deemster Call It and it was dismissed. And that's not a live application before this court, and they shouldn't be allowed to bring in Jamil by the back door. So those are the 7 points in response to damage. As regards to prejudice to Mr. Nugent, the principal damage to a defendant is the effect of delay on his ability to properly defend a case. And that comes from Cairns and Jones. Paragraph 8, subparagraph 5, which is page 1288. And in the same authorities bundle, in Carroll and the Chief Constable of Greater Manchester Police, at paragraph 42, which begins page 1304, this is the Master of the Rolls, that at subparagraph 6, it's noted that the prospects of a fair trial are important, but the part I rely on here is the fourth line, where it says, Limitation Acts are designed to protect defendants from injustice of having to fight stale claims, especially when, and the end clause, there are no documents to assist the court in deciding what was done and why. And so it's submitted that whether documents are available to assist the court is a relevant factor. And that this is allegation, the primary allegation is an allegation of VAT fraud, and the evidence is primarily documentary. There are a number of examples of the documents in the bundle, and that it isn't a case where the defendant, the effect of delay on the defendant's ability to properly defend a case is the same as it might otherwise be. The substance of this case is whether or not there was VAT fraud, and that is really going to be a documentary exercise. The second point about why there's limited prejudice to Mr. Nugent is in his own witness statement, which is in volume 1 at page 136. At paragraph 20, he says specifically, my memory of those events is fairly good. It's fair to draw the court's attention to the final sentence where he says, my memory is not as good as it would have been as the proceedings been issued with the limitation period. But this, again, is an exceptional case because this is well-travelled ground. And Mr. Nugent has given evidence, I'm instructed over 3 days, in the action before Lady Justice Rose. But he's saying there in terms, in a witness statement signed with a statement of truth, that his memory of these events is fairly good. The effect of the absence of Mr. Goubet, as to that I would say, firstly, that Mr. Goubet is not the defendant here. There is a defensive justification, and to go back again to Mr. Nugent's witness statement, and I would ask the court to pay particular attention to this and emphasise it, is paragraph 11, so page 134. The middle of that paragraph, I believe and continue to believe that what was written in the letter concerning the claimant was true, for the reasons which are outlined in the particulars of justification at paragraphs 30 to 58 of the defence. And this is something I submit that weighs heavily in the scales in favour of Mr. Willers in terms of the prejudice to him by the loss of the action. The fifth point on prejudice is that proceedings were issued before Mr. Goubet died. And although it is said that the allegations of malice weren't raised until later, it was very apparent what the issue was, which was the substantive VAT allegations. And it was open to the appellants to seek evidence from Mr. Goubet. The sixth aspect is the practical aspect of, in reality, what would have happened here. Deems to call it, as has been noted, was the judge seized of the Goubet and Willers action in the Isle of Man. And I think it's worth looking at a passage from his judgment in Order 0911, which is in volume 6, at page 1169. It's right, it is right to say that this, I should draw the court's attention, this is a judgment that was delivered on the 5th of December 2017, so it post-dates the matters that we're concerned with. But to look at the 1169 paragraphs 493 onwards is his assessment of the conduct of Mr. Goubet. And
This is in the case of Goubet and Willers.
yes,
Yeah.
yeah, the front page of that judgment is at 1167. And the other paragraph that I would draw the court's attention to, the committee's attention to, I'm sorry, is 522, which is on page 1172. And this is the point that Mr. Willers wasn't asked a single question in cross-examination by Mr. Goff on the issue of mischarging of VAT. And so the extent to which the death of Mr. Goubet causes prejudice to Mr Nugent may not be as great as the appellants would have you believe. And so for all of those reasons, it's submitted that if it is the case, which the respondent strongly urges the committee not to embark upon, that it's concluded that this is there has been an error that warrants interference with the discretion below, that all of those factors mean that this committee should support the conclusions of Deemster Corlett for the reasons that he gave, and take into account the fact that he was uniquely in a position to form a view as regards the evidence of the effect of the delay as regards Mr Gube's evidence because of his because the fact he was the judge in charge of the Gube and Willers matter. And that, in conclusion, the basic question is it fair and just for the defendant to have to respond to the claim, notwithstanding the delay in commencement? It's submitted that in a case like this, where a letter has been sent to Customs and Excise without the knowledge of the claimant, where it's a serious allegation made under the cover of a professional firm of accountants, that this is something that it is fair and just for the defendant to have to meet, and the claimant should not be deprived of his opportunity to seek vindication on this issue. Unless I can assist the committee any further, those are the submissions of the respondent.
It appears not. Thank you very much, Ms. Nicholas. Thank you.
Ms Michaelos has boiled down or distilled the issue before the committee to the question of whether the Deemster's exercise of discretion was within that generous ambit of discretion within which reasonable divergences of view are possible. I can deal with that quite quickly by going back to something I said earlier, but it does appear to require re-emphasis, and that is the way in which the Deemster approached this issue in paragraph 47. Now, true it is that the Deemster did not say that the only delay falling to be considered was that between discovery of the letter and the issue of proceedings. That's the point that was made in the Staff of Government division. But it was nevertheless the inevitable effect of what he said by treating it at paragraph 32 as the relevant delay. By treating the relevant delay as that being between discovery and the letter of the issue of proceedings, it then followed that the Deemster would go on, as he does at paragraph 47, to treat the question for his decision as being whether that delay had caused the relevant evidence to be unavailable. And that he could answer simply because it was only on the 5th of January 2016 that Mr. Gube died. So we say that he has wrongly defined the ambit of the evidence that was relevant because of his mistaken approach to the construction of the legislation. Can I now turn to the Cairns-Jones case, which the committee have in bundle 6 at page 1285. Ms. Michaelos introduced that by saying that it was similar to the present case, but in reverse. Why then did she describe it as being in reverse? The position appears to be that in the case which involved not just Mr. Cairns-Jones, but as one sees from paragraph 9, 2 other claimants, the course of action did not begin to run until either the appellant had ceased to be employed or ceased to work as an upholsterer. I derive that from paragraph 5. And then Lord Justice Elias deals with Donovan and Gwentoys in a way which is consistent with what might otherwise have had to be our submissions. And what one sees from paragraphs 9 and 10 is that this case was different from the present one because the lengthy delay was after the acquisition of knowledge. Here, the lengthy delay was from the date of publication, and the period of delay after acquisition of knowledge until the inception of proceedings was only a part and a small part of that delay. I think I can make the point good if we go to Lord Justice Elias's conclusions at paragraph 29 on page 1293. As Lord Kerr's pointed out, the criticism, such as it was of infelicity in the structure of the judgment, hence the description an error of the most technical kind, not a description which in my submission can be applied to what happened here. And Lord Justice Elias goes on, the delay with respect to those periods was plainly highly material in this case in assessing the forensic prejudice to the defendants. The relatively limited delay between the expiry of the limitation period and when the action was commenced is of no real significance here, and it didn't prejudice the defendant. Indeed, the judge recognised that when he considered paragraph B. The error, therefore, is not, in my judgment, one of any materiality. So the judge considered the period of delay from the date of constructive knowledge, and that was of no real significance, said Lord Justice Elias. In the present case, the delay over the same period was from October 2010 until December 2013. So it was significant and can't be described as being of no material significance. The construction issue I can deal with very quickly. Ms. Mikolos says it's not necessary to make a decision. Of course, as the committee has pointed out, availability is essentially a yes-no question, what Ms. Mikolos calls a binary issue. Cogency is a question which may involve considerations of degree of diminished cogency, and that, of course, is a factual issue. Let me turn now to Mr. Goubet's death. True that Mr. Goubet died after the action was brought, but I invite the committee to take the view that the critical point in relation to Goubet's death is that it was, the death was before the extent of the litigation was increased by Mr. Willis's amended reply to allege a malicious vendetta and a whole series of allegations against Mr. Nugent, tarred with the brush that Mr. Willis wishes to paint Mr. Goubet with, which his advocate had previously declined to plead. It must have been a matter considered by Mr. Wandenborough when doing the original reply, whether in response to the defence of qualified privilege he could plead malice. And if that assumption is correct, then it follows that he decided that there was insufficient evidence. And despite the length of the amended reply, the committee may well think that the lack of particularity is striking when compared with the gravity of the allegations made so lightly. It's also not without interest that it was only after Mr. Goubet's death that the application was made to lift the limitation bar. That was on the 29th of January 2016. I'll just give the reference, it's bundle 4, page 298. The proceedings, of course, had been issued in December 2013, but the application not until just over 2 years later. Let me move now to ground 2. The first point taken by Ms. Mikolos is that objectively a period of 5 months and 2 years is not unreasonable. I have to accept that that is not, well, it's not easy to accept that. A specialist in defamation, had he or she been instructed, would see at once, first of all, the urgency of the matter by reason of the limitation point. They would want to get on with it. It's not, in our submission, something that Ms. Mikolos can pray in aid, that the period included the long vacation. That would only be relevant if we were told that counsel had been instructed, but he or she, regrettably, was on a journey to the Antipodes to see their family. That's not the case here, and it really isn't open, in the absence of such evidence, to Ms. Mikolos to pray that in aid. I should say, incidentally, that the length of the long vacation in the Isle of Man is fixed by rules. It runs, regardless, I think, of the particular year and whether it falls at a weekend, from the 24th of July to the 31st of August. That's Rule 2.9 brackets 1 of the Rules of the High Court of Justice on the Isle of Man, 2009. If one looks at the documents that had to be settled, they were not remotely challenging. Can I just ask you to go to bundle 5? First of all, to the letter of claim at 1089. This is a relatively short letter. Its terms are formulaic. It could almost have been set up on a template. And so far as the particulars of claim are concerned, which the committee can see between pages 1094 and 1097, they are little more than 3 pages. They set out, as indeed they were bound to, the natural and ordinary meaning, but that in a letter relatively short is not a substantial challenge for an experienced specialist practitioner. I was wondering how long it would have taken me to do it when I was a junior. I did inquire if Mr.
That's so long ago, Mr. Brown, you probably can't remember.
So I asked Mr. Dean as well, and I'll put it neutrally because I mustn't give evidence, but really, probably.
Anyway.
Well, can I put it like this? Invite the members of the committee to think how long it might have taken them to draft the letter of claim and the particulars. And it's very hard to say that it would be more than a day's work. And on one view, it would be half that. So I can't accept what Ms Mikolos says about the period of delay being objectively reasonable, and since it is unexplained, I'm entitled to pray and aid the Wisniewski doctrine. Ms Mikolos refers to Manzi and King's College Hospital, but that was a case where there was an explanation for the absence of the evidence, as one sees in paragraph 30. Bundles 30, bundle 7, page 1394. Now, I was glad to see that there was another reference to entitlement, but can I just explain why my submission, it can't be used to tease me, and it's really this. I've not suggested that the court is never entitled to draw factual inferences. My point is that on the exiguous or non-existence evidence in this case, there is no entitlement to draw factual inference. Indeed, the Deemster, in the course of argument, said to counsel, I can't assume anything, I've got to have evidence. But it's a pity that that approach didn't follow through into his judgment. The relevant passage, just because that is worth looking at, is in bundle 3, page 666. Mr. Quinn for Mr. Willers at the foot of 666 is asking the Deemster to accept that advice was given, but we're not told by whom or when or on what subject. And at the bottom, Mr. Quinn presses the point by saying proceedings have been drafted. Indeed they have. And the Deemster then says, all right, I've no idea, I can't assume anything, I don't think, Mr. Quinn, I've got to have evidence. And one can see that there are then further exchanges between Mr. Quinn and the Deemster, and at line 9, Mr. Callin, who is instructing me today, says, and one can sympathise with him on this, there should be evidence of that, Your Honour. And his warning, sadly, was not taken to heart. Ms. Mikolos says that one of the reasons, or possible reasons, for delay is that it was necessary to go into the background of the other litigation. But as one sees, if one looks at the draft particulars of claim, bundle 5, 1089, that there is nothing in that pleading at all by way of claim for malice or aggravated damages linked to other issues in other litigation. It was only with the amended reply settled by Mr. Willers in person that, as I said, the ambit of the issues was extended to embrace other litigation. So it appears that the other litigation is just an ingenious piece of, if I may say so, speculation on the part of Ms. Mikolos. Turning to the issues of prejudice, I won't deal with all of them. Indeed, Ms. Mikolos went through them with such admirable speed, I'm not sure I noted them all down, but I think I got the important ones. First of all, she makes the point that in defamation, compensation exists for injured feelings. But the basis of that compensation is the injured feelings as a result of the damage to reputation. She described the Brady case, which the committee have at bundle 6, page 1078, as the starting point. but it is clear from Brady that vindication is one of the most important factors of a libel action. And vindication, of course, is public vindication. And if the libel has not been made public, then vindication is hardly required, indeed not required in a case such as this. There's no suggestion that it leaked out. There's no evidence of it being on file, and that was merely a speculation on the part of one of the members of the Staff of Government Division. And above all, there is, and this is critical, there is not an iota of evidence, nor is it suggested by Ms. Mikolos that there might be, that the document is publicly accessible. It was only obtained by Mr. Willers in this case because he sought it under a subject access request.
Can you just go back to you saying there's no evidence of it being on file? Whose file?
Well, I imagine it was being suggested that it was on the file of the Customs and Excise.
Isn't that where he got it from in his subject access request?
Well, the point I see why you picked me up on that. I quite understand.
And also because didn't they bank a cheque?
Well,
which was sent with the letter?
Well, doubtless there would be something on file. My point is that it wouldn't be publicly accessible. It's accessible to Mr. Willers because he was the subject making a subject access request.
Can we strike through the no evidence of it being on file?
Well, yes, I'm sorry, I didn't express myself as well as I should have done, but I hope your ladyship has got my point.
Yes, I do.
Not publicly accessible. It may not still be on. Well, Mr. Dean says it may not still be on file. I mean, we simply do not know. And in the absence of knowledge, then it doesn't avail Mr. Willers.
Is the Staff of Government entitled to assume that it's on file if the procedures are being followed properly?
Well, we're now quite a long way down.
You don't need to answer that.
No, all right. Okay. Thank you. Well, can I now just turn to damages? The suggestion is that there may be hidden damage, and we were reminded of that classic passage of Lord Bingham's about percolation, hidden springs, and so on. But if the defamatory sting was percolating through hidden springs, it would have surely leaked out by now, and by now there would be some evidence of damage, even if it were not possible for Mr. Willers to locate the precise means by which that damage had occurred. So that again, I respectfully submit, is no more than speculation. Compensation, says Ms. Mikolos. Well, compensation has to be related to the true extent of any damage to reputation or feelings. She tries to extend the possibility of substantial damages by saying that depends on the way in which the case is run. Well, there are members of the bar who run libel defences in a manner which has led to aggravated damages, but they are relatively few and far between. And it is not every case in which justification is run as a defence which entitles the claimant to demand aggravated damages. So far as malice is concerned, well, I've already made my submissions on that. Grave though the allegations are, there is a total lack of particularity to make them convincing, and it's hardly likely to result in aggravated damages. Then, on the prejudice to Mr. Nugent, the prospect of a fair trial to Mr. Nugent, something that Sir Terence Etherton noted in Carroll was important, is one which obviously concerns him very much, the ability to defend the case. There may be documents, but it's an odd point to be raised when the The fear has to be that the documents are so many that they are more a hindrance than a help to getting to the truth. And when one comes to deal with stress, Mr. Nugent gave evidence over 3 days, and that, as you would expect, was mainly cross-examination after his witness statement had gone in chief, followed by a period of re-examination. So we say it would be wrong, it's only one of the factors, but it would be wrong to put him through all of that again. And then finally, in relation to the passages from Deemster Corlett's judgment of the 5th of December 2017 in the Isle of Man litigation, and the excerpts relating to Mr. Goubet and Mr. Willows, and in particular the passage cherry-picked to show the view of Deemster Corlett that Mr. Goubet was not in all respects credible. I would simply say that criticism of Mr. Goubet doesn't taint Mr. Nugent. And from what you've seen of Mr. Nugent, he has, in my respectful submission, been able to preserve his professional objectivity and independence. And indeed, on one view, in writing to the Revenue, he was doing a public service. Thank you. That completes my submissions.
Thank you very much indeed, Mr. Brown. I don't think there are any further questions that the board has to put to you. We're most grateful to you, all of you, both of you, for your oral and written submissions and the economy with which you have presented this interesting case to us. And the board will now take time to consider what advice they will humbly tender to Her Majesty, and we'll let you know in the usual way.
Thank you.